ये बंद हो गया, ये इससे ऑडियो बंद हो गया।
So, good afternoon, sir. Clearly audible and visible to everyone.
Yes, you are.
So,
Yes.
both the judges and teams. So, shall we start vote? Sim Shukla, sir, are you there?
Yes, I'm here. I have joined.
Thank you so much, sir. So,
Thanks for waiting.
a very wonderful afternoon to everyone. My name is Prakash Singh, and I welcome you all in the semi-final round of first Lex Explore National Moot Court competition, organized by the Lex Explore Legal. For the very first, I would like to introduce our honorable judges of this round. Honorable judges of this round are Dr. Yash Tiwari ma'am and Sushin Shukla sir. We are delighted to have you both. Now, I would like to welcome our both the teams of the semi-final round. We are delighted to have such wonderful mooters here. Today, we have with us Team Code 48 from the side of petitioner and 46 from the side of respondent. Each team shall be allotted a total of 40 minutes, out of which each speaker can take maximum 20 minutes only, and 5 minutes may be allotted for rebuttal and sir rebuttal. Speaker of both the teams will be notified in the chat box when 2 minutes are left for each speaker to indicate the time. Since both the teams and the judges have joined with us, now I declare the court is in session and let the speaker one of the petitioner side plead, followed by the speaker two.
Good afternoon, ma'am and sir. Sir, can you just give us 1 minute? Actually, he is trying to join. He is facing some technical issue. Just 1 minute, please.
Firstly, I would like to ensure that I am clearly visible as well as clearly audible.
Yes.
Much obliged. Court master, may I approach the virtual dice? Much obliged. May I please the court? Actually, due to the technical error, I am not able to switch on my camera. I have rejoined, though also I am not able to switch on it. So the council plead ignorance on that part, Your Lordship.
All right.
Much obliged. The council solicits the permission to begin, as Your Lordship.
Yes.
Much obliged. With the Constitution in my heart, I, along with my co-counsel, is present here on the behalf of petitioners in an instant case of Mr. Chotelal versus Union of Indiva for the purpose of hearing before the Honorable Court. The council craves the presence of leadership. With the kind consent, may I address the bench collectively, as Your Lordship?
Yes, you can.
Yes,
Much
you
of
can.
In the disputes today, we have raised total of the 4 issues. Out of these 4 issues, I shall be dealing with first 2 issues, and I'll be taking total of 18 minutes of the court's time, furtherance to which my co-counsel will be taking total of 17 minutes of the court's time. We shall respectfully reserve 5 minutes for the rebuttals. Your Lordship, would you appreciate a brief perusal of case in hand, or can I directly jump on with my submissions?
Just give a brief about.
Okay, surely,
Yeah.
Ladyship. Your Ladyship, in this particular case, Mr. Chotilal and Kiran Kumari marriage was solemnized on 1st of January 2020. But to provide this facts in a crux, it's all about the dowry debt, the demand of dowry under Section 2 of the Dowry Prohibition Act 1961 by the Mr. Chotilal to the Kiran Kumari and her father. So actually what has happened in this case, there is 3 instances of demand of dowry in this particular case. The very first instance is given in the para number 1, that of 10 lakh rupees for purchasing a luxury car. Second demand of dowry can be seen, a demand of 50 lakh rupees. And third demand can be seen in very third para is that there was a demand of 60 lakh rupees. Due to the non-fulfillment of rupees 30 lakh, on 15th of October 2022 at about 9 a.m. Kiran Kumari died out of the strangulation. Your Ladyship, the doctor also found several contusions on the hands, axilia, and other parts of the body. As the body was highly decomposed, the doctor referred the same to the head of the Department of the Forensic Medicine Medical College. Your Lordship, during investigation, the police recovered a diary written by Kiran Kumari, wherein she had narrated how her husband used to make a demand for dowry. The plea of accused was one of the denial, and he stated that when he returned from his office in the evening and entered the room, he found the deceased hanging from the hook in the ceiling. Your Lordship, this needs to be noted that the trial court, having examined the evidence of the material witness, held that this is the case of strangulation, and therefore the death was unnatural, and that there was a demand of dowry and there was a cruelty on the part of accused, and accordingly convicted him under Section 304B and 498A of Indiva Penal Code. Your Lordship, now, on the behalf of Chotilal, as a legal representative, we have filed a special leave petition to this Honorable Supreme Court under Article 136 of the Constitution of India. So this court has decided to hear the petition today and frame the 4 issues as I have earlier said. Your Lordship, now, if the court is well versed with the facts of the case, the counsel seeks permission to move on with the submissions. The counsel. Yes, Your Lordship. The counsel seeks the permission to move on with my submissions.
Yes.
Yeah, please proceed.
Much obliged, Your Lordship. Much obliged. My very submissions in this regard, as Your Lordship, is that whether SLP filed by Mr. Chotilal is maintainable under Article 136 of the Constitution of India or not. The counsel submissions in this regard is affirmative. Your Lordship, I would like to submit this argument under 4 limbs. My first limb of argument is that there available wide jurisdiction of the Supreme Court under Article 136 of the Constitution of India, 1949. Secondly, there was unjust conviction of Mr. Chotilal on the grounds of suspicion falling short of proof. And thirdly, there is a large difference between the strangulation and hanging. Fourthly, there was no proximity or live links between the effect of cruelty based on dowry demand and the death concern. Without any further ado, I would like to move on with my first limb of submission under this issue. Your Lordship, there available the wide jurisdiction of Supreme Court under Section 136 of the Constitution of India 1949. So, Your Lordship, according to the Article 136 of the Constitution of India, which allows this Supreme Court to grant a special leave to appeal against any judgment, order in any matter or case made by any court or tribunal in the country. The Supreme Court is vested with the absolute power of interpretation of the Constitution, being the ultimate guardian of it. In the authoritative pronouncement of Goneka versus State of Kerala, AIR 2000, Supreme Court at page number 2587, the discussion was about the exercise of jurisdiction under Article 136 and if it's consisted of granting of the special leave petition and subsequently hearing the appeal. I hope my lordships are with me.
Yeah, please proceed.
Yes.
Much obliged, Your Lordship. Your Lordship, The special leave petitions can be filed against any judgment of the High Court within the 90 days, which is a prescribed limitation period from the date of the judgment. However, there is flexibility. We agree there is flexibility at the discretion of Supreme Court judge. Or it can be filed within 60 days against the order of the High Court refusing to grant the certificate of fitness for appeal to the Supreme Court. So, Your Lordship, these are not my words. These are inspired from the precedents which was decided by several cases in catenaries of judgments. Your Lordship, as recently in 2016, the Constitution Bench of Supreme Court in Mathai George, 2016, 7 Supreme Court cases at page 700.
Counsel,
Yes, Your Lordship.
dear counsel, I want to ask you one question. You
Much
are
obliged.
quoting so many judgments in favor of the SLP that you have filed. Just prove your maintainability, how your petition is maintainable in this particular case.
Much obliged, Your Lordship. I will do the same. I'm very grateful to you. Your Lordship, coming to the same is that my second limb of argument is regarding is in regard with your question. Your Lordship, there was unjust conviction of Mr. Chotelal on the grounds of suspicion falling short of proof. So in the present matter, Your Lordship, it has been obliterated and the investigation has proceeded in a casual manner as to whims and fancies of the investigation agency. The court in many cases added that 100 culprits can escape, but one innocent person should not be punished. The available materials in this case expose the perfunctory and designed investigation. Very recently, on 29th of May 2021, the former Chief Justice of India, N.V. Ramana, observed in the judgment that due to the precarious nature of Section 304B, judges, prosecution, and defense should be careful during conduct of the trial. If I have satisfied your Lordship, may I move on?
Yes, proceed.
Much obliged, your Lordship. I am very much grateful to you. Your Lordship, and if perchance an innocent person was wrongly convicted of on the basis of such a drastic presumption as in Section 113B of the Indiva Evidence Act, it could then be said in tune with the Paley and Granville Williams that he had fallen for the sake of his society and that some risk of convicting the innocent could not be avoided in public interest. Your Lordship, while the above rules ensures the protection of an individual against a possible unjust conviction on the grounds of suspicion falling short of proof, that is a sort of moral certainty on the basis of which an ordinary prudent man will agree to act. Does it also afford sufficient protection to the society? By successfully bringing offenders to book, or does it not provide an opportunity for a scores of criminals to escape the law? Thus, an idea is steadily gaining ground as to whether so rigid a standard of proof as ever and as incorporated in Indiva Evidence Act 1872. Your Lordship, Palsy, who is an eminent jurist and also a great well-known social political thinker, he too took umbrage against this excessive solicitude to protect an individual innocent at the cost of the interest of the society as whole. So he joined issue with the maxim called "Let 10 guilty person escape, but not an innocent person suffer," because of the imperative social need of convicting the guilty. Your Lordship, I would like to cite a case of
Counsel?
much obliged, your ladyship.
There are so many instances from the fact sheet. It is clear that the evidences are against him, and you're stating that there are lack of evidence.
Yes, much obliged, your ladyship. As you mentioned that there was a lack of evidence. There was not lack of evidence, and all the evidences were against the accused. Let me come to the diary that was recovered during investigation. Your ladyship, when you look to the para 6, I would like to direct the court attention to para 6, last 5th and 6th line. Para 6 of the Moot proposition, last 5th and 6th line. During investigation, police recovered a diary written by Kiran Kumari, wherein she had narrated how her husband used to make demand of dowry. Your ladyship, here the word how. Here the word how does not mean the cruelty. Here there was misinterpretation done by the done by the respondents in this particular case as your ladyship. And also when we talk about the plea of alibi, as it is said that all the things are against the accused, then why he had took the plea of alibi? Because plea of alibi is an exception to the exception in the matrimonial cases, so they are taking a false plea of alibi. The term how can't be taken as cruelty in this particular case as your ladyship. If I have satisfied you, may I proceed?
Counsel, but demanding for dowry itself is a cruel act. Don't you think so?
I agree with you, ladyship. I completely agree with you. But in this case, the evidences which were brought on record was not up to the mark, because it is not directly because when we go by the definition of dowry death under section 304B of Indiva Penal Code 1860, it is clearly written that there should be infliction of cruelty soon before death. But there is no cruelty. It is just as a finding of the High Court. But according to the document, the diary which was recovered, there was no such cruelty. Direct life links and proximity cannot be generated in this particular nexus of the case, as your lady said.
Counsel, the fact sheet is clearly stating that she has been subjected to dowry for several times. She has been left to her parents' house. She has been left to her parents' house many of the times. Don't you think so that this is a cruel act?
I completely agree with your leadership. I am very grateful to you that there was demand of dowry. She was subjected to the dowry, and facts it are very much clear about the demand of the dowry. But here, by the way of a special leave petition, we are here to reverse the judgment of the trial court and high court, because in the trial court and high court there was no such contention made that the taking of dowry or giving of the dowry is an offense under section 2 or 3 of the Dowry Prohibition Act 1961, though it is upon the discretion of the court to take the such matter into the consideration.
Mr. Counsel,
Much obliged, your lordship.
you are saying that you are trying here to reverse the judgment of the High Court.
Yes,
Right.
your lordship. Yes, your.
It can only be possible in a situation if you are able to explain the errors in the judgment of the Honorable High Court.
Definitely, your lordship. Can I proceed further by establishing this case?
Yes, just focus on the errors made by the Honorable High Court in their judgment. Okay, then only your case can sustain.
Very grateful
Right.
to your lordship. Very grateful. Surely, your lordship. So let's come to the very major point here. It's first I would like to conclude my second limb of arguments and directly jumping upon your question. So in a nutshell, it can therefore be said that the view of escalating crime and escape from the punishment, our law regarding burden of proof needs a more balanced and pragmatic reassessment today than has been the rule here too. So, your lordship, the line which needs to be focused on in regards to your question is that there is a large difference between strangulation and hanging. So, by these means, the case can be reversed in this particular case. I will establish further. So, under this, what I would like to contend is that in the present appeal, the learned counsel for the respondent has sought to change the stand as to nature and the cause of death of the deceased. It is contended that the strangulation can be explained as according to them, deceased has committed suicide by hanging herself. So, the post-mortem report, as observed, has specifically opined the cause of death of the deceased was strangulation and not hanging. So, in the instant case, the ligature mark on the neck of the deceased was opined to be continuous in the post-mortem report, thus leading to an inference that death was on account of strangulation. Your lordship, it needs to be noted that the learned counsel for the respondents in their written submission has contended that that could have occurred because of self-strangulation. But it is observed by the bench in the Sunil Tuggal and others versus State on the 25th of February 2019 that the similar arguments by the learned counsel for the respondents leads nowhere. According to the bench, strangulation and hanging are two completely different causes of death. So, coming to the main question through which I will establish that there was an error in the judgment, that what is difference between the hanging and strangulation? Strangulation is a asphyxia by closure of a blood vessels or and or air passages in the neck due to the external pressure, as your lordship. In this facts of the case, she was died due to the strangulation, and the meaning of strangulation is external pressure, your lordship. Not only her body weight while committing the suicide, but external pressure was applied. But contrary, coming to the hanging, is a suspension of a person's body with compression due to the body's own weight. So in this case, your lordship, what I'm trying to establish is that there was external pressure was applied while she was doing the suicide. External pressure, maybe some other person other than the accused has approached her, who has helped in abatement of suicide, which was not accused, because my client was not present at the spot, and for that we have substantiated the argument before the trial court and the honorable high court. So the judiciary has also taken the same view in the Surinder Kumar versus State Delhi Administration, a case of 1987. One Supreme Court cases at page number 467, the accused was tried for murdering his wife by burning. Your lordship, the incident occurred about 10 months after the marriage. Hence, it is satisfying the very rule of 304B. In his defense, he took the plea that the death was accidental owing to the bursting of the kerosene stove. But there was a dying declaration which clearly mentioned that he was in the habit of ill-treating his wife, and that on the morning of the incident, he has abused and beaten her. So the court has convicted him under section 302. Your lordship, the court has convicted him under section 302 of Indiva Penal Code. So in this particular case, what I am trying to substantiate is that the respondents have clearly interpreted the term strangulation, but they haven't come up with the meaning of that, because strangulation is by the external pressure. But at the time of the commission of the offense, at the time when the offense has taken place, the accused was not there at the spot, and someone else other than the accused has helped in the commission of the suicide, who will be liable for the abatement of suicide in this particular case. If I have satisfied your lordship, may I move on to my fourth limb of arguments?
Yes, proceed further.
Much obliged, your lordship. I am very much grateful to you. Your lordship, there was no proximity or live links between the effect of cruelty based on dowry demand and the death concerned. So the word dowry ought to be ascribed an expensive meaning so as to encompass any demand made on a woman, whether in respect to the property or a valuable security, which is defined under section 30 of the Indiva Penal Code 1860, of any nature. The bench of ex-Chief Justice of India and V. Ramana, Justice A.S. Popanna, and Hema Kohli said that in this case, the trial court convicted the husband and father-in-law of the deceased under section 304B, 306, and 498A, that is cruelty of Indiva Penal Code 1860. Your lordship, it was found that the accused has been demanding money from the deceased for constructing a house which her family members were unable to give. As a result, she was constantly harassed and subjected to cruelty, finally leading her to commit suicide. So in appeal, the High Court held that the demand of money for the construction of house cannot be treated as a demand for dowry. So I repeat, in appeal, the High Court held that the demand of money for the construction of house cannot be treated as a demand for dowry. The Supreme Court observed that the offense under section 304B was not established against them, as demand allegedly made on the deceased was for money to construct a house, which cannot be treated as a dowry demand for connecting her to the said cause. Your lordship, next I would like to analyze a term which is soon before death, which has been laid to several questions in the judiciary. What actually the term soon before death is. So in this context of section 113B Evidence Act and section 304B, the court has several times noted that the expression soon before death used in the substantive section 304B of Indiva Penal Code 1860 and section 113B of Indiva Evidence Act 1872 is a present with the idea of a proximity test, as lordship. What actually a proximity test is that? That there is no definite period which has indicated an expression soon before death is not defined anywhere, because it can be the the term soon before cannot be implemented as immediately before. So there must be existence of proximity and live links between the effect of cruelty based on dowry demand and death concern. So if the alleged incident of cruelty is remote in time and has become stale enough not to disturb the mental equilibrium of the woman concerned, it would be of no consequences, Your Lordship. It will be of no consequence. Your Lordship, I would also like to cite a very recent case of Parvati Devi versus State of Bihar, now State of Jharkhand, 2022 case, live law, Supreme Court at
Counsel,
page number
please,
7.
Counsel, please sum up your arguments as your time is over.
Much obliged, Your Lordship. As I noticed, my time has expired. The council seeks the extension of just 2 minutes. I will just conclude this argument and I will move on to second issue and conclude it. Can I, ma'am?
Just 1 minute.
Yes, ma'am. I'm completely trying to do it. Much obliged. Yeah, so your Lordship, the said presumption is, however, rebuttable and can be dispelled on accused being able to demonstrate through cogent evidence that the ingredients of section 300B have not been satisfied. Without any further ado, I would like to jump on my second submission. The second submission is in regard to whether the diary written by the Kiran Kumari can be considered as a piece of dying declaration. The council's submission in this regard is negative. The diary does not apparently states the husband has inflicted cruelty on the deceased in relation to the demand of dowry. Secondly, the diary has not passed the test of reliability. Thirdly, is that it is not like one size fits all. And fourthly, the evidence produced on record was not scrutinized with care and caution. So, Your Lordship, when you look upon to the para 6, last 5th and 6th line, as I already mentioned, during investigation, police recovered a diary written by Kiran, wherein she narrated how her husband used to make a demand of dowry. So, Your Lordship, this court in the Nalapati Savya versus SDO has observed that the one decision has cautioned that the court have always be on guard to see that dying declaration was not the result of either tongue or prompting or the product of imagination. So next, moving on to my second limb of argument, that diary has not passed the test of reliability. So, Your Lordship, in order to pass the test of reliability, in the case of Kushal Rao versus State of Bombay, the court has observed that a dying declaration has to be subjected to a very close look, keeping in the view that the fact that the statement has been made in the absence of the accused, who has no opportunity of testing the veracity of the statement by cross-examination. So, Your Lordship, I am like to move on to my third submissions in this regard, is that the Supreme Court has observed in the case of Surinder versus State of Kerala, it was 3-judge bench case in which ex-Chief Justice of India N.V. Ramana, Justice A.S. Bopana and Hema Kohli has observed that the evidence of the deceased wife under Section 32 of the Evidence Act 1872 with respect to the cruelty could be admissible in a trial for a charge under Section 498A of the IPC. This is, however, subject to the satisfaction of two preconditions. The very first condition is that her cause of death must come into question in the matter. Secondly, the prosecution will have to show that the evidence that is sought to be admitted with respect to Section 498A of the Indiva Penal Code must also relate to the circumstances related to transaction of the death. So, Your Lordship, also, I would like to conclude my arguments by saying that evidence produced on record was not scrutinized with care and caution. Referring to Section 32 of the Evidence Act, the bench said that the phrase, your lordship, the phrase cases in which the cause of that person of death comes into the picture, comes into the question, is broader than merely referring only to the cases where there is a charge of murder, suicide, or dowry death. Referring to the old judgments in Paramananda Ganga Prasad versus Emperor, AIR 1940, Nagpur High Court.
Counsel, your time is over.
Your ladyship, just give me 30 seconds. I will conclude. I am just concluding, ma'am.
Conclude, please conclude.
Much obliged, Your Lordship. Your Lordship, I would like to humbly submit before the Honorable Court is that in this particular case, regardless of the nature of the proceeding and that for the purpose of which such evidence is being sought to be admitted should be a part of circumstances of the transaction relating to the debt. But in this particular case, there was no cruelty inflicted by the accused in relation to the demand of the dowry and the debt concerned. So it is most humbly and respectfully submitted before this Honorable Court is that the special leave petition is fit for maintainability, and this the diary can't be admissible as a piece of dying declaration. Without any further ado, I would like to give the floor to my co-counsel who will be dealing with remaining two submissions. May I please the court?
Yes.
Much obliged to ladies. It was very well pleaded before the bench.
Thank you, counsel. A very warm greetings to the bench. As my co-counsel said, I will be dealing with remaining two issues and will take 20 minutes of the court's time. The counsel solicits to begin, your lordship. May I please
You
the
are
court?
dealing with which issues?
Much obliged, your lordship. I am dealing with two issues. That is, first one is whether the judgment of learned trial court and honorable high court is erroneous, and second one is whether section 304b and 498a of IPC 1860 is unconstitutional. May
Right,
I
right. Proceed.
may I proceed, your lordship?
Yes,
Please
yes.
proceed, counsel.
Much obliged, your lordship. Issue 3, whether the judgment of learned trial court and honorable high court is erroneous. Mr. Will Chamberlain has rightly said that no one is perfect. Your Lordship, the same is true also with regard to the court. Your Lordship, their judgments are not infallible. There are possibilities of mistake and misunderstanding, despite given all the arrangements to guarantee a fair hearing and a correct judgment too. Your Lordship, each and every human built entity is vulnerable to fallibility. Thus, this also relates to the court rendered judgments, Your Lordship. When a court makes a mistake, makes a wrong decision, it is termed as a mistake of law, Your Lordship. Your Lordship, in the case of Dharna Das, the court held where the subordinate court fails to observe the essential fact or evidence in adjudicating the case, which result in a wrong decision or a lack of justice. Your Lordship, the diary recovered during the investigation has been framed as a dying declaration, which is highly unjustified as the diary wasn't properly scrutinized by the court with care and caution. Diary written by Dickies only states how her husband used to make demand of dowry, not cruelty. The Dickies have not mentioned about the cruelty. Therefore, considering dying declaration, diary as a dying declaration is not fair, Your Lordship. Your Lordship, in case of Chira Shivraj versus state of Andhra Pradesh, the court held that relying on the dying declaration is an extremely dangerous mechanical approach simply because it is there. Your Lordship, the court shall examine the death declaration scrupulously with a microscopic eyes and to find out if it is voluntarily genuine, made in the conscious state of mind and without being influenced. And if such conditions is fulfilled, the court held that the order of a conviction cannot be declared on the basis of sale of the dying declaration, Your Lordship. Your Lordship, miscarriage signifies failure, whereas justice can be interpreted as justness or righteousness. Therefore, miscarriage of justice symbolize the failure of pronouncement of what is right and what is just. Your Honor, miscarriage of justice occurs when an innocent is held as guilty, thereby providing ways for the actual guilty party to escape from the scene. Your Lordship, the criminal justice system is supposed to be designed as such that it includes both the punishing the one who is declared guilty and acquittal of the innocent too. Your Lordship, if there occurs any absence of one of these elements, miscarriage of justice will definitely take place, Honor. Your Honor, wrongful prosecution and humiliation of the innocent party is the consequence of miscarriage of justice. Your Honor, miscarriage of justice can not only happen through the courts, but can also happen through the investigation officials at ground level too. Innocent suffer from the same also, Your Lordship. Your Lordship, the principle of presumption of innocence till proven guilty shifts the burden of proving the guilt to the prosecution, Your Lordship. But in certain cases, like those related to Section 498A of IPC, the burden is shifted to the defendant, Your Honor, who is left at the mercy of the prosecution, including the police, till he proves his innocence, Your Honor. Your Honor, Section 498A of the IPC is one such law that is now often used as a weapon to settle personal scores rather than being used as a shield against the harasser. Your Honor, the entire purpose of such law fails, rather backfires when it is used as a weapon rather than a shield by those for whom it was created to act as a safeguard. Your Honor, I will refer a case in versus Ramdev. It was observed that a right of appeal is not an intrinsic or universal right. It is a legal right and must be governed by the statute that grants it. In this way, the losing party has the opportunity to get the decision reviewed by the other independent judges. The court that determines an appeal will correct the errors made by the subordinate court and endeavor to arrive at correct decision as far as possible, Your Honor. Your Honor, to quote former US President Theodore Roosevelt, no man is above the law and no man is below it. Nor do we ask any man's permission when we ask him to obey it. Obedience to the law is demanded as a right, not asked as a favor, Your Honor. Your Honor, a division bench of
Counsel?
much obliged, Your Lordship.
Counsel, the fact sheet is stating that the accused was constantly demanding for the dowry, and still you're stating that the accused was innocent. And
Much
it was
obliged, Your
yeah.
Much obliged, your ladyship, as many of the facts were not properly have seen, like in the proposition itself. It is stated that Kiran Kumari went to her father and asked for 60 lakh rupees. In the proposition, it is not mentioned that Mr. Chotelal have asked her wife Kiran Kumari to go to her father and ask that 60 lakh rupees amount. It is only stated that Kiran Kumari went to her father and told him. Point to be noted, Your Lordship, in third paragraph, first and second line of the moot proposition. You kindly see it. Here it is written, Kiran Kumari went to her father and told him that Chote Lal asking rupees 60 lakh. Told him, Your Honor, told him. If I have satisfied Your Honor, may I move further?
Can you, Counsel, can you please refer to the paragraph number 2 of fact sheet?
Yeah. Sure, Your Honor.
Wherein it is clearly mentioned that Chotalal Kumar demanded rupees 50 lakhs for purchasing a plot. And on 5th of August 2020, Chotalal Kumar took his wife and left her in her parents' house and told them that Kiran Kumari could get back to the matrimonial home only upon the payment of 50 lakh rupees.
Much obliged, Your Honor. Your Honor, I have seen that. Much obliged. Also, in the second paragraph, it is written in last second line that Chote Lal Kumar had a change of heart and he brought the wife back to his home and also apologized her and promised to keep her happy, Your Honor. And after that, he haven't demanded any money. Only Kiran Kumari went on 10th September 2022 and told her father about the money.
Okay.
If I have satisfied Your Honor, may I move further?
Yeah, please proceed.
Much obliged, Your Honor. A division bench of D.Y. Chandrachud and M.R. Shah found itself at pains, Your Honor, to note that the order passed by the Allahabad High Court granting bail to murder convicts lacked total clarity as to which part of the judgment and order could be said to be submissions and which part could be said to be the findings or reasonings. Your Honor, observing that writing judgment is an art, though it involves skillful application of law and logic, the Supreme Court said. The Supreme Court said it is very unfortunate that by this judgment we are required to observe the importance of judgment, purpose of judgment, and what should be contained in judgment. The ex-Chief Justice of India, U.U. Lalit, had spoken extensively about the issue of criticism of judgments, Your Honor, criticism of judgments, judges, and by extension the court. He told, we are ultimately public servants. Whatever we decide is for the public good. The public has the right to see whether our judgments are up to the expectations of society or not. Ex-Chief Justice UU Lalit stated. However, he also stated, however, criticism of courts and judgments must be within bounds. He stressed. At the same time, there must be a line that must be drawn. If people feel that a court has gone wrong in any viewpoint, they must be criticized. Any criticism is a pointer that even the judiciary can do some course of correction. It is a healthy sign in any democracy, Your Honor, but that criticism should be within bounds. Therefore, Your Honor, I would like to conclude this issue by stating it is my most humbly contented before the Honorable Court that judicial miscarriage breaks down the very fiber of what is necessary for a functional judiciary citizens who believe the Honorable Court are fair and impartial. Your Honor, the judiciary cannot exist without the trust and confidence of the people. More than any other branch of government, the judiciary is built on a foundation of public faith, Your Honor. Your Honor, now with your due permission, I would like to move on to the issue number 4. May I?
Yeah, please proceed.
Much obliged, Your
Yes.
Honor. Issue number is 4. Issue number 4 is whether Section 304B and 498A of IPC 1860 is unconstitutional. Your Honor, the need for general neutral laws is being increasingly felt because of the increase in the incidence of male and transgender victims and the misuse of provision enacted for the protection of women by the women. Your Honor, instances of misuse are a concept of modern society. This has been happening for years. Your Lordship, women are not only put false allegation on the men, on their or their husband and their relatives, but also use such provisions as a mean of threat to coerce the man and relatives into doing things according to her wishes, Your Honor. Your Honor, the provision of Section 304B was enacted to curb the rising instance of dowry death in the country. However, rampant misuse of these provisions has been seen. Your Honor, it was seen that an estranged wife will go to any extent to rope in as many relations of the husband as possible in a desperate effort to salvage whatever remains of an estranged marriage. Furthermore, in Balbir Singh versus State of Punjab, Your Honor, the Honorable Court observed, though the amendments introduced in the penal codes are within the laudable objects or eradicating the evil of dowry, such provisions cannot be allowed to be misused by the parents and the relatives of a psychopath wife who may have chosen to end her life for reason which may be other than cruelty. Your Honor, the court also stated the glaring reality cannot be ignored that the ugly trend of false implication in views to harass and blackmail an innocent spouse and his relative is fast emerging. Your Honor, Parliament enacted the Protection of Women from Domestic Violence Act in 2005 for empowering and protecting the women from instances of mental, physical, and emotional abuse in their home. Your Honor, this legislation is also inherently gender specific and does not recognize male victims of domestic violence. Your Honor, under this act, an aggrieved person is defined especially as a woman. Your Honor, the Honorable Supreme Court also, while discussing such cases, has time and time again and again reiterated that most of the complaints are filed in the heat of the movement over tribal issues and are not bona fide. And at the time of filing the complaint, implications and consequences are not visualized. Your Lordship, as I stated earlier in the last issue, Section 498A of the IPC is one such law that is now often used as a weapon to settle personal scores rather than being used as a shield against the harasser. Your Honor, the entire purpose of such law fails, rather backfires when it is used as a weapon rather than a shield by those for whom it was created to act as a safeguard. Your Honor, in a recent case on 5 May
Counsel,
year, a businessman from Odisha named Rahul Agarwal committed suicide by jumping off a building. After the tragic incident, a video surfaced on various social media platforms in which the deceased was seen narrating his ordeal of being. Sorry, Your Lordship.
uh, please continue. I'll ask little later.
Okay, okay. Much obliged, Your Lordship. Your Lordship, in a recent case on 5 May, a businessman from Odisha named Rahul Agarwal committed suicide by jumping off a building. After the tragic incident, a video surfaced on various social media platforms in which the deceased was seen narrating his ordeal of being falsely implicated in a dowry harassment case booked under Section 498A of IPC by his wife and her family. His parents too were accused in the case, and the deceased expressed his helplessness at not being able to do anything in that regard. Your Your Honor, as a proud citizen of my country, Your Lordship, where women is worshipped, it is very painful to say that a data published by NCRB. The disturbing fact was that while rate of charge sheeting in case under 498A of IPC is 93%, the conviction rate was only 15%, Your Honor. The rest 78 walks free. Only this rest 78% walks free after a full judicial process, only in the eyes of court of law, Your Honor. The rest of their life, the society punishes them as an accused who have been proved innocent in the court of law cannot walk free for rest of their life, Your Honor. Your Honor, in it is held in the case of Your Honor.
Mr. Counsel,
Yes, Your
all
Honor.
these arguments are all right to say. Right? But see, you have to establish the question of law. SLP relies on the question of law that is left to be decided by the high courts, right?
Much
है ना?
obliged, Your
Show
Lordship.
this. है ना?
Much,
Everything is against you. कि, the death has been committed within 7 years, right?
much obliged, Your Lordship.
And a diary is also recovered as a dying declaration. है ना? And
Much
there are
obliged.
so many facts which itself establishes that dowry was demanded. You have already discussed in one of the point, right? So give some evidences that are in your favor, right?
Much obliged, Your Lordship. Can I further move to argument or and also under 302 murder by some other person, by some other person
See,
according to
counsel,
such.
see, Mr. Counsel, we want to know any question of law that is left to be decided by the court, high court, right?
Much obliged, Your Lordship. Can I? I will further. I will refer to a judgment. Judgment. Can I move further?
Yeah, sure, sure.
Much obliged, Your Lordship. It is held, Your Lordship, in the case of Preeti Gupta versus State of Jharkhand, reported that there is a tendency to misuse the provision of 498A of the IPC 1860 and involve all relation of the husband in the matrimonial matters. Your Honor, it is further held that the court should examine the allegations so that those family members who have been unnecessarily dragged into litigation are saved. Your Honor, in cases of Shilpa Sharma versus State, GV Rao versus LHV, Prasad, Preeti Gupta versus State of Jharkhand, Geeta Malhotra versus State of UP, Anish Kumar versus State of Bihar, Rajesh Sharma versus State of UP. The honorable court in paragraph number 17 of its pronouncement held that if false implications by way of general omnibus allegation made in the course of matrimonial disputes are left unchecked, the same would result under the misuse of the process of law. Paragraph number 70 is being reproduced as under. The above mentioned decisions clearly demonstrates that this court has in numerous instances expressed concern over the misuse of section 498A IPC and the increased tendency of implicating relatives of the husband in matrimonial dispute. Your Honor, without analyzing the long-term ramifications of a trial on the complaints as well as the accused, it is further manifest from the state judgments that false implications by way of general omnibus allegations made in the course of matrimonial disputes, if left unchecked, would result in misuse of the process of law. Therefore, it was held that this court, by way of its judgment, has warned the court from proceeding against the relative and in-laws of the husband when no prima facie case is made out against them. Your Lordship, in case of Shivaji Janab Patil versus State of Maharashtra, the court held that for bringing home the guilt in context with Section 498A or Section 304B of IPC, there has to be a specific evidence to show that bride was harassed, ill-treated, treated with cruelty on number of occasions which was sufficient enough to prompt her to commit suicide. And Your Honor, in the particular case, as there is no evidence regarding the cruelty or number of occasions, harassment or ill treatment, Your Honor, there are no such kind of evidence. The court cannot afford itself to be aloof or informative of normal human behavior and human transactions which are being transacted in day-to-day routine life. Your Honor, there are there are petty quarrels or brushing or conflicts on number of counts in day-to-day life between bride, her in-laws, her husband, the sisters, or the brothers of husband. Your Honor, every such petty bickering or disagreement cannot be treated to be cruelty in parlance of law in respect of section 498A and 304B of IPC. If they are to be taken into sweep of the provision of these two sections, then it would be very difficult for the person to survive in the normal domestic life. Your Honor, now I would go with my last submission, that is demand of dowry cannot be taken cannot be taken to be cruelty, as my friend also covered that topic. Your Honor, in the case of K Prem S Rao and Yadla versus Yadla Srinivas Rao, for proving the offense punishable under section 498A and 304B, the harassment, ill treatment, cruelty has to be proved as law requires. Small bickerings, again, your lordship, small bickerings, incidental acquisitions do not amount to ill treatment as contemplated by law, Your Honor. Your Honor, these are normal phenomenon of a human life. Intention behind such quarrels, bickerings, and acquisitions has to be seen, Your Honor. Your Honor, casual loss of temper and resultant acquisition do not amount to cruelty in legal parlance. The evidence
You
recorded
are
in this case is very insufficient to bring home, Your Honor.
hello, am I audible?
Yes, yes, Your Honor.
So it means you are okay with the demand of dowry.
No, Your Honor. Actually, see, Your Honor, a demand of dowry cannot be taken as a cruelty, Your Honor.
Cannot be treated as a cruelty.
Cruelty, Your Honor.
Which law says?
Your Honor, in the case of K. Prema S. Rao and others versus Yadla Srinivas Rao and others, for proving the offense punishable under section 498A of IPC, the harassment, ill treatment, cruelty has to be proved as a law requires. Small bickerings, incidental acquisitions do not amount to ill treatment as contemplated by the law. Your Honor, these are the normal phenomena of a human life. Intention behind such quarrels, dowry, bickerings, and acquisition has to be seen, Your Honor. Your Honor, casual loss of temper and resultant acquisition do not amount to cruelty in legal
Counsel,
parlance,
counsel,
Your Honor.
demanding dowry is a pleasing act.
Much obliged, Your Honor. It is not a pleasing it is not a pleasing act if it is forcefully, if they are demanding.
Obviously, there is a force behind it.
Much
Demanding,
obliged.
demanding a luxurious car. Don't
You
you
much
think so? Is a forcible act.
Much obliged, Your Honor. But you can see as the much obliged, Your Honor. As you can see, this kind of demands are generally customs and traditions. Dowry demands are also in their customs and tradition in the Hindu ceremonies. And both Mr.
Counsel, any custom, if the custom or the traditional practice is immoral, can you, okay, how can you validate that practice?
Much obliged, Your Honor. Your Honor, if the dowry, the tradition of dowry becomes immoral and illegal as well when it is demanded as a forceful, Your Honor, not when the tradition and customs are to be followed.
She was subjected to mental harassment when she was left to her parents' house.
Yes, ma'am. Much obliged, Your Honor. Your Honor, generally, as I stated, by referring the case of K. Prema S. Rao and versus Yadla Srivas, generally small bickerings, incidental or bickering and such quarrels used to happen between husband and wife. These are normal phenomenon of a human life and married life as well, Your Honor. This cannot be taken as very serious offense or offense.
Can we take demanding for dowry as a normal phenomenon, counsel?
Ma'am, again, Your Honor, again, I am saying that it can, when force doesn't exist, that means the dowry of demand is valid. And when we have to follow the tradition, culture, the demand of dowry.
Counsel, which law says that? Which law says that?
Yes, yes.
Much obliged, Your Lordship. Your Honor, when as custom will prevail over law, Your Honor.
What are the
According to
essentials
Hindu
of
law,
custom?
Your Honor,
What are the
according to
essentials? An immoral custom can become a law.
Your Honor, again I am repeating that it will become immoral when force is applied, when repetition and again asking of dowry is applied, Your Honor.
Counsel,
Again,
if
what means
if the
again and
luxury
again?
Under your much obliged, Your Honor, according to Hindu law, section 2, clause A, custom will prevail law, Your Honor. When custom will prevail law, Your Honor. When if the
There are
customs
certain
are
counsel, you are proving, you are validating they are demanding dowry is not illegal.
yes.
Much obliged, Your Lordship. Your Lordship, it is illegal. I am not denying that point. But Your Lordship, when tradition and cultures are to be followed, when customs are to be followed, then it is not.
What type
And
of
accord
custom,
and
type
according
of
to much obliged, Your
are
Honor.
to here? What type of customs, what type of traditions are to be followed? What type of customs and traditions will
Much
treated as a law or
much
prevail over
obliged,
the law?
much obliged,
You
Your
are
Honor.
talking of the Hindu law. This is not the definition of a custom that you are explaining to us.
Much obliged, Your Honor. According to section 3, clause A of the Hindu Marriage Act, the
Move
expression
on your
custom.
next, you can move on your next argument, right?
Much obliged, Your Honor.
Counsel, just sum up in 10 seconds as your time is already over.
Yes, much obliged, Your Honor. Your Honor, casual loss of temper and resultant acquisition do not amount to cruelty in legal parlance. The evidence on record in this case is very insufficient to bring home the ingredients of Section 498A and Section 304B of Penal Code. There is no ground to draw indifference as indicated by Section 113A and B of Indian Evidence Act. Therefore, demand of dowry cannot be taken to be cruelty as contemplated. Yeah, therefore, I am therefore I would like to move on to my prayer. Before that, I also want to state that instead, Your Honor, this case is a classic example of a woman using as a weapon the very law that was made to protect her. Much obliged, Your Honor. May we move to the prayer of relief?
Yeah, please proceed.
Wherefore, in light of the issues raised, argument advanced, and authorities cited, it is most humbly prayed before this honorable court may please to declare the special leave petition filed by Mr. Chote Lal is maintainable under Article 136 of Constitution of India.
Secondly, to struck down the judgment of learned trial court and honorable high court.
Third, to adjust the diary written by Kiran Kumari can't be admissible as a piece of dying declaration.
Thirdly, it is most humbly submitted before the honorable court is that to adjust the diary written by the criminal Kiran Kumari can't be admissible as a piece of direct declaration, as well as to declare the section 304B and 498A of the Indiva Penal Code 1860 is unconstitutional.
Fourth, to declare fourth, Your Honor, and or the act and or pass any order, direction, or relief that honorable court may deem fit in interest of justice, equity, and good conscience. For this act of kindness, the council on the behalf of appellant shall duty bound forever. It was humble pleading, Your Honor.
It was pleasure pleading before the court.
The council seeks permission to collectively address the bench as Your Honor.
Yeah.
Much obliged, Your Honor. The council will be representing the respondent. I am the first counsel and I will be dealing with the first issue and the second issue. And my co-counsel will be dealing with the third issue along with the prayer. The council seeks permission to proceed with the facts of the case.
come to the arguments directly, issues directly.
Much obliged, Your Honor. Uh, the counsel seeks permission to address the first issue of the argument.
Yes. Okay.
You may proceed with the arguments.
Much obliged, Your
Okay.
Honor. The special leave petition brought before the Honorable Supreme Court by the petitioner is not maintainable because no special circumstances exist in this case and substantial justice has already been done. There is no substantial question of law involved and there is no error in the previous judgments. It is contended by the respondent that the appellant must show exceptional and special circumstances exist and grave and substantial injustice has been done. However, in the current case, the Learned Trial Court and the Honorable High Court have already examined all the facts of the case and have, in consideration to the principles of natural justice and law, have given a judgment that is fair and that is fair and right. Uh, Also, there is no miscarriage of justice and a fair trial was given to the accused in the current case. Also, it is to be kept in mind that the right of appeal is neither a natural or inherent right that is attached to litigation. It is only permitted in cases where there is a substantial question of law. The case of Chunilal V. Mehta and Sons Limited versus Century SPG and Manufactured Coal Limited, this honorable court had laid down the following tests to determine whether a substantial question of law is involved. The tests were as follows: whether it directly or indirectly affects the substantial right of parties, and the question is of general importance, and whether there is an important question of law that has not been decided previously by the any of the high courts or the Supreme Court. However, in the current case, the question that is a matter in the case has already been decided by a lot of judgments by the courts previously, and therefore those judgments can be used as a precedent for the current case, and therefore there is no new question that is existing in the current case that needs to be dwelt on. Also, in the case of Bihar Legal Support Society versus Chief Justice of India and Dhankeshwar Cotton Mills Limited versus Commissioner of Income Tax, it was stated that the jurisdiction under Article 136 is extraordinary and can be accepted only in exceptional and special circumstances, and only when the judgments given by the previous courts are not fair and arbitrary. However, in the current case, there was no miscarriage of justice. The judgments were not erroneous. The accused was given a fair trial, and the judgment was given on the proper examination of facts and laws. There was no violation of law and natural justice, thereby rendering the judgments valid. Thus, the special leave petition under Article 136 is not maintainable. The council seeks permission to proceed with the second issue.
Please proceed.
During the investigation of Kiran Kumari's suicide, police recovered a diary written by Kiran wherein she narrated how her husband used to make demands for dowry. The trial court had rightly considered this as a piece of dying declaration, and the High Court had concurred with the view. Dying declaration is an important piece of evidence, and conviction can be solely based on dying declaration, and this will be proved through our arguments in the arguments made by me further. In the present case, when there is a spat of dowry that's in the current scenario, dying declaration has assumed much importance. Dying declaration, according to Section 32(1) of the Indiva Evidence Act 1872, enumerate that statement, whether written or verbal, made by a person relating to the cause or circumstances of the death of the person, and the death of the person is in question in the case, such statement will be relevant. The word statement used in this section does not imply that they must be communicated to another person. The diary in this current case is a cry for help, and therefore just ignoring it because it was not communicated to a person would be unfair and should be no ground for dismissing it. Also, it is not necessary that there must be a direct nexus between the circumstances and death. It is enough to be proved that if the words spoken by the deceased refer to any circumstances which have connection with the transactions which ended up in the victim's death, then the statement will be considered as a dying declaration. Also, the courts
Counsel?
Yes, Your Honor.
Is there is any role of proximity of time for dying declaration?
Yes, ma'am. Yes, Your Honor. There is a role of proximity of circumstances and death. However, it is held by the Supreme Court in its previous judgments that it must not be considered in a very concise manner. It can have a wide interpretation. And in the current case, it can be seen that the demands for dowry, the harassment related to it, the fact that she was even removed from her house for the demands of dowry can also show that the circumstances that she mentioned in the diary related to harassment and the death are in close proximity, and can be thus the diary can be considered that there was a relationship between the circumstances and death, and thus can be
Counsel,
considered as a dying declaration.
counsel, soon before her death, there is no inferences that she has been subjected to dowry.
Your Honor, on 10th of September 2022, Chotelal Kumar asked for 60 lakh rupees, and this was a demand made by him, and thus this could be just the start of another cycle of dowry, even despite he claimed that he had a change of heart. So this was one instance, and they,
Counsel,
like the previous.
counsel, the fact sheet is silent about it, that whether it has been demanded. I mean, it could have been taken as a help. There was
Uh,
no mention of the fact that she has been again subjected for dowry.
Ma'am, in a case by the in a previous judgment, it has been stated that the 60 lakh rupees that is can be considered as dowry in the case of a dowry death. It will be further cited by my co-counsel in the proving that the judgment of the court convicting the accused under 304B and 498A is correct. In that, it would be proven by my co-counsel.
Okay, please proceed.
Much obliged, Your Honor. Uh,
Counsel, before you proceed, I have a one question for you.
yes,
That
Your Honor.
you were discussing in your previous argument about the substantial question of law, right? Petitioners petitioners are claiming that they were not provided the proper opportunity of hearing, right?
Yes, Your Honor.
So don't you think the principles of natural justice are violated by the honorable court by not
Uh,
providing them the proper opportunity of hearing? So this is obviously a question, substantial question of law that has to be decided by this court.
Your Honor, in the current case, the previous courts had examined the witnesses and all the facts in the case, and therefore they rightly have ignored the plea of alibi because it was not considered to be relevant in the case, and that the case that the judgments by the trial court have some. Have some reason behind doing that, and the same will also be proved by my co-counsel in the further arguments relating to why the judgment given by them by the previous courts is not erroneous.
Right. Proceed further.
Much obliged, Your Honor. In the case of Ramnath versus State of Madhya Pradesh and Kushal Rao versus State of Bombay, the court accepted that the plea of the defendant that the diary is a reliable document upon the sole basis of which the accused can be convicted was stated, and the dying declaration recorded in the exact words stated by the declarant is of great importance, and the statement was made at the earliest opportunity. In the present case, the diary was authored by the deceased, and the declaration by the deceased was on a diary which was day to day, and it was a direct representation of the what was the situation in the hand by the deceased, and also at the earliest opportunity it had been put forth as an evidence by the uh, prosecution in the current case, and therefore it should be admissible. Also, uh, there also, there is neither any rule of law or nor any prudence that dying declaration cannot be acted upon without corroboration. This was held in the case of Munnu Raja versus State of Madhya Pradesh. Also, the rules stating that the person recording a dying declaration should obtain doctor's certificate and endorsement about mental fitness is a mere rule and not the ultimate test as to whether or not the said dying declaration was truth or voluntary, is held in the case of Kamala via versus state of Karnataka, the defense of the deceased not having a medical certificate does not apply. And in the addition to that, the Supreme Court assumes every person of age. Of age of discretion to be sane. This was held in the case of Shirali Wali Muhammad versus state of Maharashtra. Uh, in the current case, the diary was kept by the deceased, narrating the narration demands of dowry, which is undoubtedly voluntary and was not tutored and prompted. Therefore, it was truthful since it was a private book and she had no reason to lie. The habit of journaling in a diary about the circumstances that were occurring is sincere and accurate, and there was no plan of falsification. Also, in the case of Ranjit Singh versus State of Punjab, the in the case, entries in a diary kept by the deceased relating to the arrival and stay of his wife and her relate by made by him relating to the arrival and stay of his wife and her farmer and the incidents which then occurred were admitted as a relevant under his this section in a trial of the wife and her farmer for the murder of the husband. Uh, Also, the diary in the current case corroborated with the statement of the deceased, which said that there were demands made for a dowry towards them, and their daughter had to constantly come back to them and was sent to them with demands for dowry made by the husband. Uh,
Mr.
because of yes, Your Honor.
The diary that you are saying is a dying declaration, whether it is a substantive piece of evidence or corroborative.
It is a substantial piece of evidence because it was held in the cases of Ramnath versus state of Madhya Pradesh and Kushal Rao versus state of Bombay. That dying declaration is important, and it can also be used as a sole piece of evidence, and it can be it has a great importance in while dealing with the case.
Without corroboration, it can be accepted, counsel?
In the current case, even with corroboration of the statements of her parents, because they were evident of how the demands of dowry were constantly made to them and that daughter was sent back to them. So it is clearly evident that demands for dowry were made by the husband here in the current case.
Please proceed.
Proceed further.
Much obliged, Your Honor. Through all of this, we can conclude that the dying declaration had an evidentiary value, and it stands proof that it can be considered as a dying declaration. Now, I ask my co-counsel to deal with the third issue.
At this juncture, the Council would like to point out all the submissions made by the co-counsel are without prejudice to those made by the co-counsel, and along with the Council will be presenting one distinct issue. The Council pleads that the judgment given by Trial and High Court is not erroneous. The courts are right in holding the accused liable under Section 498A and 305B of Indiva Penal Code, and substantial justice has already been done. The acts of the accused amounted to cruelty under Section 498A of IPC. The word cruelty, as defined in the explanation B of 498A, says that harassment of a woman with a view to coerce her to meet any unlawful demands for any property or any valuable security. Dowry demanded is included in the unlawful demand as contemplated above. Dowry was demanded by Chotilal in multiple instances as seen in the facts of the case. He demanded lump sum amount of money twice, a luxury car, and a plot. He even sent her home to her parents' house and told her not to return until she brought 50 lakh rupees along. These acts have led to her death. Cruelty for the purpose of offense need not even be physical. Even mental torture or abnormal behavior may amount to cruelty and
Counsel.
harassment in a given case. Yes, Your Honor.
The fact sheet is stating that when she was sent to her house for bringing 50 lakh rupees, thereafter her husband's mind was changed and he apologized for the same. Right.
Yes, Your Honor.
And
Yeah.
don't you think so that the matter of dowry ended there?
Your Honor, allow me a moment. Your Honor, in the absence of there being any specific purpose for demanding 60 lakh rupees, there is a presumption that this amounts to dowry as well. It was held in the case of Jivendra Kumar versus Jaydar Singh and others that any money or property or valuable security demanded by any of the persons mentioned in Section 2 of the Dowry Prohibition Act at or before any marriage, reasonably connected with the death of a married woman, would necessarily be in connection with the marriage, the facts of a given case clearly and unequivocally point otherwise. Thus, in the present case, though Chotelal claimed change of heart, his demand for 60 lakh rupees on 10 September would be considered as dowry, as it was reasonably connected with the marriage. If Your Honor is satisfied, may I move on?
Yeah.
Move on.
Cruelty for the purpose of offense need not even be physical. Even mental torture or abnormal behavior may amount to cruelty and harassment in any given case. This was held in Gananath Patnaik versus State of Orissa. In Savitri Pandey versus Prem Chandra Pandey, the Supreme Court has mentioned that mental cruelty is the conduct of an other spouse which causes mental suffering or fear to the other. Kiran Kumari in the present case had to live in constant fear that when Chotelal again would demand for dowry and when again the cycle would continue of her being kicked out of the household. Cruelty therefore postulates a treatment of the other with such cruelty as to cause reasonable apprehension in her mind that it would be harmful for her to live with the other party. And it will not depend upon the number of times that such incidents have occurred or the continuous course of this offense, but or the instances in general and the impact, the gravity, and the intensity of it in the deceased's mind. There was also physical cruelty in the present case. In the instant case, the facts point out that in the post-mortem conducted, there was contusions on the chin, hands, axilla, and other parts of the body. The medical term for a bruise is contusions. Bruises are a type of bleeding under the skin. A sharp blow, or such as from falling or colliding with a large object, can break tiny vessels called capillaries. This causes the bleeding in the area of injury. Thus, it can be logically deduced that the physical abuse was also meted out in the victim in connection with the demand for dowry. The respondent humbly submits that the essential ingredients of Section 498A of INDIVA is fulfilled. After analyzing the facts of the current case, it can be deduced that the constant demand of dowry and sending to her parents' house and not letting her return to her matrimonial house until the money is brought is reasonable to show that the woman was under mental stress and pressure due to harassment by the accused and can be convicted under Section 498A of IPC. He is also liable under Section 304B of IPC. The acts of the accused amounted to offence under 304B of IPC. The Supreme Court confirmed that where the husband has demanded a specific sum from his father-in-law and on it not being given has tortured or harassed his wife, this will qualify as a demand for dowry, which is this case law. Ashok Kumar versus State of Haryana is very relevant to our particular case because the facts and circumstances of the case represent exactly the facts and circumstances of our current case. Chotelal demanded a luxury car from the deceased and her family and even asked for money for buying a plot and told her to stay with her parents until this demand was fulfilled. This showed that if the demands were not fulfilled, she would be kept away from her matrimonial house and this would amount to cruelty. There are three essential ingredients that needs to be satisfied under Section 304B of IPC for the accused to be convicted. And in the present case, these ingredients were also fulfilled. The death of the woman must be caused by burns or bodily injuries otherwise than under the normal circumstances. Again, as shown in the medical report, there were contusions over the chin and several other contusions on the hand, axilla, and other parts of the body. This is not possible when a person dies by hanging. It's difficult to have contusions on hand and other parts unless there's another person who was forcefully strangled or, in this current case, subjected to her to such cruelty before her death that these bruises were caused. This shows that Chotelal was involved in the strangulation or the death of the deceased and it would be considered as a dowry death. It is also essential that the death must occur within 7 years of marriage. The death of the deceased occurred on 15th of October 2022, which is 2 years and 9 months and 5 days away from the date of the marriage. Thus, the death also being an unnatural circumstance, along with the fact that it was only been roughly around 3 years, would fall within the period of Section 304B of IPC. The third and final ingredient must be that women must have been subjected to cruelty or harassment by her husband or his relatives. It is evident from the facts of the case that the dowry was being demanded by Chote Lal, and she was subjected to cruelty by being removed from her matrimonial home and asking her to not come back until these demands were fulfilled. There was also a perceptible nexus between the death of the woman and the dowry-related harassment or cruelty that was inflicted upon her. I would like to present another case which has very similar circumstances as such of the present. In Kamesh, Panjir versus State of Bihar, it appeared that the victim had been murdered by strangulation in the previous night. The court relied on the opinion of the doctor, the evidence recovered, and the testimony of the witnesses to hold that the death of the woman has been caused and otherwise under natural circumstances as expressed in 304B. And hence, it was classified as a case of dowry death. In the present case as well, there was medical report revealing physical injuries on the hands, axilla, and other parts of the bodies, and the diary being the testimony should be considered as dowry death under Section 304B of IPC. The Supreme Court, in another landmark case, Samar Ghosh versus Jaya Ghosh, has held that the concept of cruelty differs from person to person. It depends upon the upbringing, the level of sensitivity, education, cultural background, customs, traditions, and religious beliefs. In the present case as well, Kiran Kumari was a doctor and was a very educated and reputed individual and from a very affluent and prominent political family. Such kind of behavior, such as demand for dowry and removing her from the house of the matrimonial home upon the demands of Chotilal not being fulfilled, was shocking to her, causing mental trauma. It can also be concluded thus it can be concluded that the current case fulfilled the criteria of dowry death, and Chotilal should be imprisoned under Section 304B of IPC. The accused was given justice and fair trial, and the judgment of previous courts were consistent to the principles of natural justice and law. The accused's right to natural justice and fair trial have not been violated. Each one has an inbuilt right to be dealt with fairly in the criminal code. Denial of a fair trial is as much injustice to the accused as it to the victim and to the society. It may, however, be noted that the fairness of a criminal trial should not be measured in its absolute terms. After analyzing the trial, we can lead to the following conclusions. Firstly, the trial began, like any other criminal trial, began with the assumption that the accused was innocent. The accused's conviction should be upheld as the counsel for prosecution has proved beyond reasonable doubt that the accused is guilty by also adducing evidence such as the diary being the diary declaration and the medical report of Kiran Kumari. Secondly, the natural rights of the accused cannot be said to be violated as he has already been given the right to appeal according to the CRPC. In the present case, the case was tried in trial court, and then later it was appealed to the High Court, and now at present the Supreme Court is hearing to this very matter. It is also a requirement that a criminal trial in which the accused is not permitted to give evidence to disprove the prosecution case cannot be considered as just and fair in the present case, and the deceased was not prohibited from exhibiting evidence to prove his innocence. The deceased was not debarred from submitting his plea of accused. The plea of accused, not being a very reliable source of evidence, was dismissed by the trial and the high courts. The courts were, now moving on to the point, that the courts were also right in ignoring the plea of alibi of the accused. The literal meaning of alibi is elsewhere. Alibi is not a general defense envisaged in the Indiva Penal Code or any other law. It is not a general defense. It is only a rule of evidence that is recognized under the law. The plea of alibi postulates the physical impossibility of the presence of the accused at the scene of offense. In the current scenario, the accused stated that he was at his office when this offense had taken place. And when he found the deceased's body, he was too nervous to intimate the police, which shows guilty conduct. The accused took too long to report the body of the deceased, even for a nervous individual, and not caring for his duties as a husband. Quite a while has passed before the body was later reported by the father, and it was highly decomposed by then. It is difficult to rule out the physical impossibility of the accused at the scene of the offense, as the date of the commission of the offense is only known to the accused, as the body was found by him and was unreported by him, and hence the plea of alibi can easily be falsified by creating false evidence. The guilty conduct of the accused is the key, essential here as to why the plea of alibi can be disregarded. Further, we should also know that the plea of alibi is a weak type of evidence which has to be sufficiently proved. But where there is satisfactory evidence that a man has committed a crime at a certain place, and a court will never find any difficulty in rejecting the alibi. In the present case, Kiran Kumari's diary as a dying declaration and the medical report detailing the various injuries on the body of the deceased was and strangulation being the cause of the death are sufficient and highly reliable evidences which can make the plea of alibi inadmissible. The council now seeks permission to move to the prayer.
Yeah, please proceed with your prayer.
Proceed with your prayer.
Wherefore, in the lights of facts and circumstances, issues raised, arguments advanced, and authorities cited, it is humbly prayed that this honorable court may be pleased to adjudge and declare the special leave petition filed by the appellant under Article 136 of the Constitution is not maintainable. The diary written by Kiran Kumari can be considered as a piece of dying declaration, and the judgment of the learned trial court and the High Court is not erroneous. Also, to pass any other order which the court may deem fit in the interest of justice, equity, and good conscience. Thank you.
Your Lordship, with your kind consent, may I raise a rebuttal?
Yes, permission granted.
Yes, proceed.
Your Lordship, to bring into notice of the court is that they have distorted the fact according to their own requirements. Your Lordship, I will raise the four questions which the respondents needs to answer in this present nexus of the case is that that there was a principle of odi alteram partem, that is a principle of natural justice is being violated by the party. Your Lordship, case was not taken, not given the contrary look, because as we go by the facts of the case, there was contusions to which the respondents are also agreeing, Your Lordship, that there was contusions on other parts of the body. So, Your Lordship, it can be murder also, where external pressure is applied at the commission of the offense of suicide, as accused was present at his office. For that he has adduced the evidence under section 102 of Indiva Evidence Act 1872. Coming to my second question is that according to them, diary does not pass the test of reliability and admissibility. But Your Lordship, when we come to section 304b of the Indiva Penal Code 1860, they are given three conditions regarding the dowry. That the very first condition is 7 years of the marriage, which this case satisfies. But when we come to the soon before death and demand of dowry and cruelty with the death concerned, it does not satisfy the same. So it does not attract the presumption of 130b of the Indiva Evidence Act 1872. So I want the reasoning on the same in this particular question. So coming on to my third question is that according to my learned friend from the respondent, speaker one, dying declaration can form a sole basis of conviction and requires no corroboration. So, but I would like to cite the recent case of Nalapatti Sevia versus SDO. In this case, Your Lordship, it is equally well settled and need no reinstatement that our hands that dying declaration can form a sole basis of conviction. That I am agreeing as a Lordship, but at the same time, with due care and caution must be exercised in considering weight to be given to dying declaration, in as much as there could be any number of circumstances which may affect the truth. The court, in more than one decision as a Lordship, the very recent decision which I am citing, has cautioned that the court have always be on guard to see that dying declaration was not a result of either tongue, prompting, or product of imagination. Your Lordship, to bring into the notice of this court, it is the duty of the court to find that the deceased was in fit state of mind to make a dying declaration. In order to satisfy itself that deceased was in fit mental condition to make a dying declaration, the court has to look for the medical opinion. In this case, it was not taken into the consideration as a lordships. Your Lordship, my fourth question is that for the third time, husband has not demanded a dowry. In this case, I would like to direct the court's attention to para 3 of Moot proposition. Your Lordship, para 3 of Moot proposition. Para 3 of Moot proposition says that on 10th of September 2022, Kiran Kumari, your Lordship, this needs to be noted at this particular juncture, is that Kiran Kumari went to her father and told him that Chote Lal is asking for the 60 lakh rupees. But here, has been no traces can be seen that he directly has asked to the Kiran Kumari for rupees 60 lakh rupees. So she made the counsel on the behalf of respondent speaker has made two contrary arguments. Is that first she said there is only 2-time demand of dowry, and secondly she have said that after that she regarded the 60 lakh rupees demand of Kiran to her father was also a dowry demand. So your Lordship, they have cited n number of cases of later 90s and before 2000, which we have disproved with the recent cases. So your Lordship, I want the answer in these particular question. The council rests the case upon the discretion of the honorable justices of the Supreme Court. Very much obliged, your Lordship. May I please the court? It was very pleasure pleading before the court. Much obliged.
In the current case, as mentioned, related to the contusions, or in the current case, the contusions were due to the bruises, and the bruises, contusions means where the blood comes out of the blood vessel. In the current case, there was evidence of concussions on other parts of the body also. And in the current case, if suicide has been contested, then it is not possible that there are concussions on the other parts of the body other than the chin and the neck, and therefore it cannot be a suicide, and it is a murder. And also it is also the concussions are because of blows, and in the current case it is necessary to establish that there was another person. And in the current case, since we have proved that the plea of alibi is not satisfactory and is inadmissible, since it can be the presence of the accused at the place of the crime is established in the current case, it can be stated that the contusions and the were a reason of the were because of the accused, and that he is liable for the same. Also, the demand for there were demands for dowry continuously made. The fact that also the contention that the third time the demand that was made for money of 6 lakhs is not dowry cannot be contested, because it is cited in the case of Javendra Kumar versus Jaidranath Singh, that is contested, that was stated by my co-counsel. It was stated that 60 lakhs will be considered as dowry So in the current case, the demand for 60 lakhs made on 10th of September 2022 will be considered as dowry. And in the current case, her death on 15th of October can be considered as a there was a proximate relationship between the last demand for dowry and the death of the deceased. So there were demands of dowry that were made immediately prior to her death, and the third demand is for dowry. Also, the dying declaration, as considered as stated, should be examined with caution. In the current case, it was examined with the statements of the parents of the deceased, that there was actual demand for dowry. And also, since the plea of accused was inadmissible, it can be easily understood that he was not present at the place of the offense, and he had made statements demands for dowry, and thus it had been properly examined by the courts, that with the examination of facts and the circumstances and law, that there were demands of dowry made, and therefore the court was right in with caution and care had taken the dying declaration into consideration elaborately in the trial court as well as the high court, and thus the diary can be considered as a dying declaration.
Your Lordship, just to bring into the notice of this court is that they have made a very fallacious arguments on the plea of alibi. Is that, Your Lordship, in this particular case, when we go by the facts of the case, it is written that the plea of alibi was outrightly rejected, as Your Lordship, and though the accused has adduced evidence means the accused has come up with the evidence which he have in the hands, that maybe the camera clip of the office where he was present at the time of the commission of offense. So the honorable trial court and the learned high court has not taken these things into the consideration, and there can be seen a violation of principle of natural justice, that is ordi alterum partem, and there is a gross miscarriage. So then now the council rests the case upon the honorable justices of the Supreme Court of India. Much obliged.
The council puts forth that there was examination of the other witnesses, and the court, in its right judgment, had ignored the plea of alibi because it was not considered to be important in the current case, and that they had examined all of it, and that plea of alibi was adduced as an evidence, as in it was used as an evidence by the petitioner in the current case. Also,
Your Lordship, just what she have cited, I would like to make a contrary point in regards to the facts of the case regarding to the plea of alibi, where it is clearly written, as a Lordship, please Lordship, refer to para 6 last two lines, where it is clearly written that he took a plea of alibi and adduced the evidence, and she is saying he has adduced the plea of alibi. But in this particular case, he has took the plea of alibi and adduced the evidence to show that he was in office during the time of offense. That's all from my side, as a Lordship. Much obliged.
Thank you, counsel. Time for the rebuttal and survey rebuttal is already over.
Shall I end the court?
Yeah.
Your Lordship, we are
Am I audible to you,
greatly
ma'am?
thankful to you for providing this wonderful opportunity, and we are really thankful that you allowed us to plead before you. Have a nice day. Much obliged, Your Lordship and ladies.
Thank you.
Thank you.
I thank both the teams and making this event wonderful. I hope that have got top marking on their WhatsApp. To reward back the document on the same number after awarding the max marks. Notification will be communicated on WhatsApp for the final round. Thank you so much. You all may exit.
Thank you.
Thank you. All the best to all the teams.